Hello, my name is Tyler Lypkie. I'm a lawyer practicing here in Edmonton, Alberta. Our firm is called Lypkie Henderson, and one of our areas of practice focuses in the area of employment law. I'm very proud of the fact that over the last several years we've helped literally hundreds of Albertans through a whole variety of employment law situations. But today I want to talk to you about a very specific legal term. It's called just cause, and it's often thrown around by employers and their lawyers when they're trying to terminate or let go an employee from their position. And it can be quite foreign and sometimes I think misleading to employees in this situation. So I want to kind of demystify this concept and really give you a very simple answer as to what it means and how it may impact you if you're facing just cause allegations. Really what it comes down to is very simple. If an employer is letting go an employee, they're terminating their position and ending their employment, generally speaking, they have to give that employee a notice of the termination or a severance package. And generally it's a severance package, basically a financial package to compensate them for the fact that they're giving them no notice of this termination of employment. However, if there's just cause, there's no obligation to pay any form of severance package. So really what it comes down to is there a reason, a good reason that's recognized by our courts for letting that employee go? If there is, there's just cause and that's it. You know, there's no obligation financially on behalf of the employer. And so that's a very serious consideration, obviously. And if that is in fact the situation, then frankly speaking, generally there's very little that can be done for that employee. But I would emphasize that to establish just cause under Canadian law is increasingly very difficult. In fact, many academics and various legal publications and research articles would suggest that it's incredibly difficult to establish just cause. So, because most of the time, just cause is easily established where, say, you have what I call a smoking gun. You know, say an employee's stealing or they've assaulted someone on the premises. Obviously, I mean, common sense says that employee should be fired, and generally speaking, that's the result. But that's very rare. For the vast majority of people, when employers are throwing around allegations of just cause, they're citing minor performance issues or tardiness or issues, frankly, that are quite minor. And it's very difficult to establish just cause for the vast majority of employees. So if your employer is making that bold allegation of just cause, you know, take it with a grain of salt. And that's where we come in, and a lot of our work is sitting down with clients and analyzing their situation and analyzing, you know, the minor deficiencies that any employer, if you will, can come up with to give them an opinion as to whether or not there is just cause or if there's not. And if there's not, then we're going to be looking at, well, what kind of financial compensation is that former employee entitled to? So it's a very serious question, and certainly from my experience, I've certainly seen employers who are you know, less than diplomatic, if you will, throw around that term and try to pressure employees into accepting a package or to a lower severance package, if you will, or into, in some cases, believing that they don't have a legal right to a severance package. So it's a very serious question, and don't let your employer's assertions be your guide. You know, I recommend you sit down with a lawyer and get to the bottom of it so you can make a decision based on your individual circumstances. So if that's ever the case, if you're ever feeling that you know, perhaps, you know, just cause wasn't there, definitely give us a call. I'd be more than happy to sit down with you to go over your circumstances and decide if in fact you have a case or not.